Welcome to In and Around War, a podcast of the Geneva Academy of International Humanitarian Law and Human Rights on contemporary issues related to wars.
In this episode, Ilia Siatista from Privacy International discusses the protection of the right to privacy and personal data in and outside of wars, specifically with respect to data collection using new technologies and state surveillance.
Hello, everyone, and welcome to In and Around Wars, a podcast of the Geneva Academy of International Humanitarian Law and Human Rights. My name is Paola Gaeta, and I'm a professor of international law at the Geneva Graduate Institute. And today I'm hosting this episode with Antonio Coco.
Hello, Paola, and hello to all of our listeners. My name is Antonio Coco. I am a lecturer in international law at the University of Essex, a friend of Paola, and an alumnus of the Geneva Academy, where I also worked as a teaching assistant for a few years.
Thank you very much, Antonio, and thank you for your friendship, which is highly appreciated. And we are good friends, no?
Yes, we are.
Yes, and we're also very good co-hosts of podcasts, perhaps.
Hopefully.
Hopefully. So anyway, for those who have listened to our last episode, you have learned that the second season of this podcast is focusing more on the professional experiences of our guests, of the alumni of the Geneva Academy. And today we are very excited to have an exceptional guest, Ilia Siatista, who has been a former PhD student of mine at the Geneva Law Faculty. Hello, Ilia.
Hello, Paola and Antonio. Thank you so much for having me here today. It's really a pleasure. And as you said before we started, Paola, I know both of you for more than 10 years. So it's a great pleasure to be here with you today.
The pleasure is all ours, Ilia. I should say a few words to introduce you to our listeners, Ilia. For all those who are right now listening to us, Ilia is a program director and senior legal officer at the non-governmental organization Privacy International, which is based in London. And as Ilia was saying, has been a friend of mine for a long time. So welcome again, Ilia. I think we are ready to start talking about what you do at Privacy International.
Yes, indeed. I mean, what is interesting for me to know, and perhaps to our listeners, is what do you do for this organization? Or could you tell us what does the organization promote and what's your job about?
Yes, with pleasure. So Privacy International, for those that do not know it, is a non-governmental organization that, as Antonio said, is based in London, but we work internationally with partners, and we research and advocate globally against government and corporate abuses of data and technology. So we would expose harms and abuses. We will mobilize allies globally. We will campaign with the public for solutions, and we'll put pressure to companies and states alike to change their policies with regard to the use of new technologies. So this is a very abstract thing. So going back to what I am doing at PI, often we abbreviate and calling it PI. So as it was said, I am a program director and a senior legal officer. So half of my job is to lead one of the 4 strategic areas that PI has that focuses specifically on state surveillance and asking for state accountability with regard to the use of new technologies. We are looking into collaborations between states and companies to conduct surveillance activities, something that has been always considered a state prerogative. Now it's often dependent on the hands of private actors. And so we are exploring these synergies, and we are trying to identify regulatory gaps, abuses, lack of transparency, and challenge them and put pressure in identifying solutions. Another part of our work is looking into what we call securing our digital life, and it's focusing on system and data exploitation, specifically, for instance, of exploiting vulnerabilities. The most famous example recently has been the Pegasus scandal.
Can you tell me more about this Pegasus scandal? I didn't follow it.
So it's been in the news for a few years now. Well, we assume it's government across the world have been using a specific type of spyware called Pegasus, produced by an Israeli-based company called NSO Group. And researchers and civil society, specifically Citizen Lab and Amnesty International, as a beginning, started then finding this type of exploit in various phones, mobile phones, of activists, journalists, and human rights defenders across the globe. One of the most famous examples where the use of this software, this spyware, has been identified has been the Khashoggi murder, the journalist of Washington Post that had been brutally murdered in the Saudi embassy in Istanbul. And there it's been identified that actually many people close to him had been targeted with this spyware close to the period around his assassination. So one of his good friends and associates, his wife, his fiancée, they were all they appear to have been targeted with this software. And what this software allows you is to basically have full access to the mobile phone without the person realizing. And that's the scariest part.
Yeah, but what do you do when you have cases such as this one, I mean, how do you make the principle of accountability be realized in practice? What do you do?
There are many actions you can take when this type of cases come, and some of them are still ongoing as we speak. So hopefully it will bring more transparency and accountability. But first of all, the one thing that Privacy International doesn't do, but others do, is identify specific individuals and brings those cases before the relevant jurisdictions of the countries where these individuals are residents and call for accountability. Another way to do it, and which has been happening, and that's an interesting part, is that by using this type of software, actually the company has violated the terms of conditions of major companies. So actually WhatsApp and Facebook, as well as Apple, have brought cases against NSO Group in the US, which is the first time that something like this is happening. Then beyond that, you can use these cases to actually bring more clarity with regard to the corporate structure and which jurisdictions they would be liable for such abuse. And then last but not least is advocate to states and before various international organizations with regard to the legislative framework around the use of this spyware and certain actions that they could be taking. So as a result, for instance, of these revelations, the European Parliament has started a special investigation into this company and other spyware companies, and we've been called in to give evidence, and they are giving specific recommendations to EU member states. The Biden administration a couple of days ago issued a commitment to actually, together with others, bringing better regulation and halt abuses around the use of such type of technologies.
Thank you, Ilia. You have mentioned quite a few times, of course, that states and governments are involved in this kind of surveillance or spying activities against human rights defenders. I was wondering if this happens, in your experience, equally in times of peace and in times of war. As you know, our podcast is called In and Around Wars. And I was wondering, do you see these kind of surveillance activities also in the context of wars?
Absolutely. It has been quite quiet until now, but I think the Russian-Ukraine conflict has brought it forward more than any other instance before, where we saw actually cyber attacks, which quite often involve the exploitation of vulnerabilities in the infrastructures of the parties to the conflict, occurring on both sides. And then also we have seen more and more as well, even humanitarian organizations that operate in conflicts being much more exposed to this type of attacks in the conflict zones where they operate.
Have you provided advice to any of these humanitarian organizations on how to deal with this kind of surveillance or breaches of their data?
I mean, it's an ongoing discussion in a way, because humanitarian organizations need to depend more and more into technologies in order to be able to conduct their operations, which makes them dependent on new technologies to provide the necessary aid. A very famous example was last year, very close to the date of the start of the war, the Russian invasion. ICRC was actually a victim of a breach where one of their servers had been attacked, and there was a major leak of data and information around their operations. There are ongoing conversations, and we've been very closely collaborating, for instance, among other, with the International Committee of the Red Cross, the ICRC, around their policies and measures they are taking to protect themselves. We've equally been talking with UN agencies such as OCHA. Office for the Coordination of the Humanitarian Affairs has been also one of our close interlocutors with regard to the necessary measures humanitarian organizations need to put in place to ensure that the data they collect do not become the target in very sensitive and dangerous zones. It is quite often, I mean, you know better than me where humanitarian organizations operate and with whom they need to talk to in order quite often to ensure the delivery of humanitarian assistance. So you can also imagine how actually the data they collect can be of much interest to different malicious actors, that they are interested in identifying the location of certain individuals, or that they would want to halt the movement of groups of individuals from one area to the next. You could do that by just tracking the movements of humanitarian officers.
Ilia, what about the data which may be collected to document the commission of atrocities? Because I guess that you could have also data collected in this regard, and then you might have an issue concerning the privacy of the victims of such atrocities. I mean, what comes first as a value to be protected? The privacy of the victims, the possibility to bring to account those responsible?
This is an excellent point with regard to actually the collision between the right to privacy and the need for bringing justice to victims. It is an ongoing battle. There has been persistent efforts to actually bring some clarity with regard to how we should be doing that. How do you balance out the desire to collect this evidence to be able to prosecute some of the most atrocious crimes in the world versus the need to actually ensure everyone's privacy and protection, and to find a balance between the two. It's an impossible exercise, but as we all know, the right to privacy also it's not absolute. There are certain interferences with the right to privacy that they are permitted, they're allowed, and if we use that as a guidance, there are certain data that could be permitted to be collected for the purposes of prosecuting crimes, as long as there are rules that they're respected and that there are certain security protocols in place. And this is, I think, something that it's an ongoing process of finding out. An excellent attempt to bring further clarity in that regard has been the Berkeley Protocol. The protocol provides guidance with regard to investigations of international crimes, but also ensure that the privacy of the people involved is respected.
Ilia, we've been talking about this collection of data for documentation of atrocities. But of course, when we talk about protecting the right to privacy, we have to understand who is the bearer of the duty to protect the right to privacy. So with respect to the documentation of atrocities, which are the entities that collect this data, and which are the entities that instead can threaten the security and the protection of this data?
So when we're thinking about who is collecting data as evidence for prosecuting international crimes, one can think of multiple actors that they are involved in the process. So you will have the parties to the conflict, that they will have an interest of collecting information from each other quite often. In the circumstances, there will be the humanitarian organizations that they are in the field and they are collecting this information. And depending on which humanitarian organization we are talking about, they are covered by different rules. So not every humanitarian organization in the field will be as restricted as the International Committee of the Red Cross to share information they collected. Then you will have UN bodies that they are also collecting information while being there. And then you have also NGOs, Human Rights Watch, Amnesty International, and others who would be very much inclined to collect this data. With the conflict in Syria, there have been organizations that have been created with the sole purpose of collecting evidence that can be used as proof. And each of them bears its individual responsibility. Traditionally, we consider human rights to be primarily binding states, but actually with the right to privacy and the developments around, especially the data protection legislation, this is directly binding anybody that collects and holds this information. And so that means that companies as well, where this data is hosted, bear a degree of responsibility.
Well, you mentioned a variety of actors which would have been under the duty, to protect the privacy in data collection. In your experience, what is the actor with which it's easier to deal with? I mean, is it the UN? Is it the private companies? Is it the state? I mean, which actor would you choose?
Ooh, such a difficult question. I would have to cherry pick depending on the situation and depending on which actor we are talking about. There will be a difference whether you're dealing with a state that has already data protection framework and it's very much keen into properly regulate with a state that has no data protection laws and they have no interest. And then also it depends on the size of the organization. Like an organization, depending on their size and the funding they receive, they will collect more data. They will have different degree of responsibility.
When you mention the size, does it mean that a smaller organization is more likely to comply with these rules, or the opposite? A bigger organization is more likely to protect data as you would wish them to protect them?
So I would say that there is no way to just answer that by simply saying that organizations with bigger size are more likely to comply or vice versa, because it really will depend on the individual case of the organization. Bigger organizations are more likely to have official processes and procedures in place. The International Committee of the Red Cross have been publicly committed to not collecting specific data, to introducing data protection principles. Smaller organizations, while they may not necessarily have such an official presence with regard to how respectful they are, they might actually have appropriate processes in place that allows them to protect. Major problem they are facing at the moment, though, is the fact that they have quite often to deal with big tech companies. When you're talking about needing to use Facebook to conduct your operations or to contact the beneficiaries, it's less likely that the organization will have any say to how Facebook deals with this data. These big companies are not created in a manner to create exceptions and more protective rules for some and less for others. They are there and have a business model to just collect data for advertisement purposes in most of the cases. And that puts especially small organizations into a very precarious situation. They really need to use these tools because most of the people will be on WhatsApp, on Facebook. But at the same time, they have to be careful because they might be putting people at risk while doing so.
What do you like of your job?
It is very interesting to working at Privacy International because every day you're faced with major ongoing problems that they shape our day-to-day lives. But at the same time, because they are so new in our lives, there is a lot of opportunity to actually become part of the change you want to see. In a way, being able to, for instance, work together with organizations like the International Committee of the Red Cross, where we published report a few years ago together called Doing No Harm in the Digital Era, where it was a frustrating exercise because we had to explain to people that, well, when you use Facebook, think of who gets this information. But also it was a breakthrough in the sense of bringing different groups of peoples and different mindsets together and trying to identify solutions that would be implementable in the day-to-day life and would allow the delivery of humanitarian aid without, although, putting people at risk and ensuring their privacy is protected. One of the best cases I've worked in and had not necessarily to do with war, but definitely with national security, has been two cases that resulted out of the Snowden revelations with regard to the mass surveillance programs that the UK government has put in place. They are collecting tons of data of millions of people, with most of them not being suspected of any crime. And having been able to bring these cases before the European Court of Human Rights and before the Court of Justice of the European Union, and being able to shape how the legislation of the UK has shifted to ensure more protections. Are they perfect? Are we fully happy with them? Of course not, but it's a step closer to transparency and accountability that we are all seeking.
If you had to choose an objective that you would like to achieve with your work, Ilia, in 2 sentences, or actually let's do it in 1 sentence. In 1 sentence, what would it be?
You are worse than an interview. What I would like to see is states introducing new legislations that actually are holding those that they are ready to abuse data into account. Whether we are talking about a company that has as a business model to exploit the data of millions, to actually make millions, to actually companies whose business model is exposing people to further abuse, like resulting to murdering people. That would be the one thing that we keep fighting for. I'm a lawyer, so my ambitions from my work are definitely much more legalistic and boring than my campaign colleagues. That would be like, let's go and take over the home offices and force them to talk to us.
Well, to be a lawyer is not necessarily boring anyway, no? Now, Ilia, you recently published out of your PhD thesis a wonderful book with Oxford University Press, and the title is Serious Violations of Human Rights. This book has something to do with the work you currently do at Privacy International, or vice versa.
Yes and no. And the face of it may be not that much, but actually the reality is that it has plenty to do with it. I've been working a lot at Privacy International into making the bridges between violations of the right to privacy and other human rights violations. Something we often forget is that privacy is a gateway right that ensures the enjoyment of other human rights. So quite often, for instance, a report issued a couple of years ago concerned how Kenyan intelligence authorities were actually using surveillance measures to identify people that they were seeking to kill or disappear. I would say this is a serious violation of human rights for sure. And then the other way it comes into play, it has to do with the fact that serious violation of human rights is increasingly used as a standard, again, which certain obligations come into play. For instance, in the Arms Trade Treaty, serious violation of human rights could be a justification for not exporting arms to a certain state. In a similar way, you have the same conversations with regard to exports of surveillance equipment. It's not as established yet, but it's definitely in it as well.
Thank you, Ilia. This has been a great conversation, and I'm a bit sorry that we have to move towards the end of our episode. But before we do that, we have to respect our tradition in this podcast to ask you for an anecdote or a story about your time at the Geneva Academy that makes you laugh or smile. something that you remember.
Or even cry. Yeah.
Or even cry, yes.
Oof, so many good memories. And
little tears, I understand, no?
And tears, good memories and tears. We were at a certain point, we were almost living there. I was feeling like we were seeing each other every day for breakfast and staying throughout lunch. I mean, one of my favorite things of living at the Geneva, working at the Geneva Academy was actually how we could use as an escape in the summer, the lake. And you would all of a sudden, out of a very nice park in Geneva with a very serious building, you would see that various inflatable items coming out the door, like we had a flamingo for a while, coming out of the door, and people would just go for a swim and come back to work.
So, as you see, to study law and to be a lawyer is not boring necessarily. One could have fun, no? Also at the Geneva Academy. So thank you so much, Ilia, for this wonderful interview. We're very glad to have hosted you, and thank you again for participating in this podcast.
Thank you, Ilia. And before we say goodbye, I would like to remind all of our listeners that you can find our podcast wherever you listen to podcasts, be it Apple Podcasts, Spotify, or any other platform. If you do not want to miss an episode, please subscribe on the platform of your choosing. And if you can, leave a review, possibly a positive one. It will help us with the algorithm to be listened by even more people.
And with data to be collected.
Exactly.
Thank you so much.
Thank you so much.
Bye.
Thank you. Bye-bye.
You've been listening to In and Around Wars, a podcast of the Geneva Academy of International Humanitarian Law and Human Rights. If you've enjoyed this episode, don't forget to subscribe and stay tuned for more inspiring conversations with Geneva Academy alumni. You can also check the Geneva Academy's website at www.geneva-academy.ch to find more resources and upcoming events on contemporary issues of international humanitarian law and policy.